morning, everyone. Thank you so much for coming to the beautiful city of Oxford. We are very lucky in this panel because we have 5 international and experienced general counsel who kindly agreed to share their views on arbitration with us today. Our idea is to have an informal conversation, and in the end, we're going to open for your questions for about 20 minutes. We have with us, on my side, Talitha Fernandez, who is a very brave and kind because she accepted our invitation to join the panel in the last minute when we thought one of the speakers wouldn't make it. And Talitha is a senior counsel and a compliance officer at the company VTTI, which is an energy company operating in over 15 countries. Before that, Talitha was part of the Whiting case team in London, where she focused on multinational infrastructure and energy transactions. Talitha also worked extensively in the oil and gas and renewable energy sectors in Latin America and in the infrastructure sector internationally. Next to her, we have Karl Hennessee. Karl is a senior vice president, head of litigation, investigation, and regulatory affairs at the Airbus group. Karl is also the chairman of the ICC Court's governing body. And before Airbus, he acted as vice president, law, technology, strategy at Halliburton, and as vice president, litigation, regulatory affairs at Airbus Toulouse. We then have Mr. Kai-Uwe Karl, Global Chief Litigation Counsel at GE Renewable, based in London. Kai is a former professor at the University of Tübingen, and he also holds a PhD from that university. Before joining GE, Karl was at Clyde in Brussels, where he advised multinational companies and sovereign clients in European competition law and state aid law. Our 4th speaker is Ivan Apsan Fridiani, legal director at BHP Billiton, Brazil, and a member of the board of the governors of Renova Foundation. Before joining BHP, he was the Legal and Institutional Relations Director of Paranapanema S.A., which is one of the major copper companies in the Americas. Our 5th speaker, who couldn't make it to Oxford today, but kindly agreed to join us by Skype, is Martin Della Valle, former global head of compliance, antitrust, litigation at Anheuser-Busch InBev in Brussels, and the founder of Zenith Source. He's a board member of Transparency International and was a founding board member of the European Chief Compliance and Integrity Officers Forum. We shall now begin. And maybe we could begin having the views from Kai and Karl. Have you been involved in situations in which it was not immediately clear whether arbitration or litigation was the better option?
No, we don't. So, this question comes up all the time. Basically, when you negotiate a contract, it's the question of the dispute resolution clause, and the question, whether it's arbitration or litigation. Typically, I think, first, I think the reality very often is that the dispute resolution clause is something that's negotiated towards the end of the entire discussion, and there are other issues that are typically more important to the business, limitation of liability, whatever technical issue, price issues. If you then come to the question of dispute resolution, and you have a choice, for example, between whatever litigation in France and arbitration in Zurich, nobody's going to make a big deal about that. You know, at least from, I mean, what your guys' experience is, but from our perspective, that's not something you would negotiate and say, look, we need to have arbitration in the contract. You don't really care. It's a completely different picture if your choice is between court litigation in a jurisdiction where you have rule of law issues, and then the alternative for you may be arbitration. In this case, you would put more importance to the question, and you would want to have a dispute resolution clause that actually protects you. So you would start negotiating, right? And you'd look into that. And then it's really a question, ultimately, and we can go into this in a bit more detail later on, it's a question of your risk appetite. You know, how far do you want to go? You know, if you have a contract, say, in Nigeria, do you want to accept local courts? Not sure. Do you want to accept local arbitration? You know, would you go for you know, ICC arbitration in Lagos under whatever Nigerian law? You know, you can start thinking about it. And then, of course, you would accept, you know, ICC arbitration anywhere in a developed jurisdiction under Nigerian law. So I think it really depends in terms of, you know, what's on the table.
If I can pick up on some of those themes, Kai, and thank you, but I also want to start by thanking the organizers for inviting us to be here today. It's an honor to be here at Oxford, but also more particularly to be asked to sit on a client panel, which is not the usual. I teach at Sciences Po, and I once had a remark from one of my students that, well, this is so refreshing to actually talk to someone who's in-house counsel. We didn't know who they were and what they did. So it's a real honor to be here with you today, particularly for the students. I'm honored to be in front of you and have the chance to show you that we do exist and this is a path you may take. But yeah, indeed, the best. But to pick up on Kai's theme, I'd like to tell you just a couple of stories from the trenches. The first does actually sort of reflect exactly what Kai says and is a little bit of a warning. I was called into a dispute, a very significant dispute, and the very first thing I do is look at the dispute resolution clause in the contract, which read as follows. Any and all disputes arising out of or in connection with this contract shall be finally resolved by the Tribunal de Commerce of Paris, which shall speak English and apply the ICC rules. Now, that is the most effective arbitration clause I've ever seen, and is a direct consequence, apparently, of the fact that it was the last clause in the contract, and according to the individual who helped draft it, they just couldn't agree, and so they compromised. So whether one chooses litigation or arbitration, one should make a choice. And I would agree with Kai in the sense that as long as you make a choice and you don't create uncertainty in the contract, almost any choice is acceptable. I, for example, have litigated a couple of claims all the way through the courts of Nigeria, and I found that while the lower courts have some challenges, once you get to the higher courts in Nigeria, especially the Supreme Court of Nigeria, the quality of the jurists and the jurisprudence is as high as any I've ever seen, and would therefore say you can make choices which seem risky as long as you understand those choices. I also would say that the choice between litigation and arbitration is not one that's simply made at the time of contracting. It's made again and again and again as the proceedings continue, and that's illustrated by the fact that I'm currently litigating a dispute, and arbitrating a dispute, and mediating a dispute, which is pending in French courts, in Brazilian courts, and in 2 separate arbitrations at the same time on essentially the same substance. So I would say it's easy for us to look in the abstract and to agree at the time of champagne drinking and contract signature that we know what we want, but we don't really know what we want until we're well into the dispute where the champagne has gone flat and the litigators have taken over.
I can just very quickly piggyback on what you said. As sponsors and investors, sometimes we are willing to take the risk and we know what is involved, but other stakeholders might not. So if you're financing a project, for example, then you also need to make banks happy, and sometimes they won't give you the chance, and they want to tick some of the boxes that you have arbitration in a seat, in a specific seat, and you have rules that you're comfortable with, and it's also something you have to have in the back of your mind if you're financing your project as well. So maybe sometimes we are willing to take the risk and we're willing to compromise, but other stakeholders are involved in the project might not have the same appetite.
And Ivan and Talitha, when you do negotiate the arbitration agreement, is that done internally, or do you engage external counsel, or it's a joint project?
I think the answer to that, it depends.
It depends.
It depends on what is the contract you're negotiating, what is the governing law. My company, for example, we are established in 15 different countries, and all the projects we're working now with the business development team, none of them is in the same jurisdiction. So we have projects in China, in Pakistan, in Myanmar, and then, well, you need support from local counsel and external counsel because you really don't understand the environment, how does it work. If it's something minor or a law that we're used to, or just you're replicating a project sometimes, which happens, then we feel comfortable to do in-house.
Yeah, I think that's, and I have the microphone here, I'm the fancy one here, just I have the microphone. So first of all, thank you very much, Felipe, it's a pleasure being here. And it's also important, as Karl said, it's important to show up sometimes and make sure that people know the in-house lawyers. We exist, we do hard work, and we are generally influencing and managing the external lawyers. So it's quite a pleasure for me to be here and to share a little bit of our experiences with you guys. And just to share a little bit of the experience that I have, so comparing the two companies that I used to work with, Paranapanema first, and now BHP. First one, a Brazilian smelter company. A second one, multinational mining, large company. We had different approaches to it, so it really depends on where you are, what are you doing, and general practices that you have in-house. In Paranapanema, I used to draft most of the contracts internally. We not always had a lot of options or space to negotiate. We had shipping predefined contracts where contracts came pretty much done in advance, and we were dealing with larger corporations on the buy, on the sell side, so we were trying to find some space there, but not always was possible for us to manage big differences and big changes. And we would generally tackle those issues internally. Sometimes when the contract was relevant or with a bigger size, we might engage an external counsel to provide some extra support. In BHP right now, we do differently, in fact. We have external counsels doing most of the work, maybe because we have a smaller team in Brazil, but also with a lot of interference and participation from the in-house lawyers. So generally we are doing hand by hand, sitting down since the beginning, because I think that the in-house lawyers, we have an exposure to the business that sometimes is a little bit difficult for the external lawyers. So combining the experiences, combining the exposure to the business that the in-house lawyer has to the skill set that sometimes the external lawyer will have, it's probably the best combinations in some occasions.
If I may speak up and suggest that something that has helped us tremendously was the development of a dispute resolution policy. And as part of that policy, which is consistently applied across all of our businesses in all jurisdictions, the learnings of the past having been brought together in order to give guidance on what are standard situations that do arise over time. It won't ever replace the legal advice that's needed in specialized situations. But it does create a great deal more uniformity and does assure that I don't ever see a clause like the one I described again.
Kai, you mentioned that you wouldn't be comfortable to go to some jurisdictions or having your contract governed by the law of a few jurisdictions. Is the other way around also true? Have you been able to identify which would be the most favorable law to apply to your contract, your business?
So in terms of the applicable law of the contract, I think we are fairly flexible. You look into you want to have some key elements. You want to be sure that the limitation of liability is enforceable. There's some other elements, and then ultimately you're flexible. It depends very much. Then let's put it this way: from our perspective, I think the dispute resolution clause is typically more important than the substantive law of the contract. You would feel comfortable with a sophisticated tribunal applying the law of a developing jurisdiction, but you wouldn't necessarily feel the other way around comfortable in going into a court where you have real rule of law issues, where you have significant corruption, and them applying a law that's on the paper perfect. And most of the time, if you look at the law, if you look at the civil code or whatever they have, the laws are fine. It's a question of how the law is applied. And in that sense, the dispute resolution clause becomes very, very important. But let me give you a kind of a practical example, something that came across my table the other day, and ask really the audience or the students. So I received an email from a colleague saying, look, we're negotiating a contract, a large contract in Nepal. And the customer wants to have Nepalese law, fine. But the customer also insists on arbitration with the Nepalese Arbitration Institute. And can we accept that? That's really the question we get. So, that's a question to the audience. What would you do? If somebody, and there's no wrong or right or wrong answer, but what would you do if, you're the in-house litigator, the business wants to sign a big contract in Nepal, and dispute resolution is, Nepalese Arbitration Center. What would you do? Would you say yes, no? What would you do? No, thank you. So, look, so any comments, thoughts? Anybody? Don't be shy. You want to go ahead?
If I was the negotiator, I would insist on English law, non-arbitration, and then after some negotiation, you end up with London arbitration, with Nepalese law. Yeah. That's the middle way to achieve.
Okay. I mean, that's of course what we do. First is, look, guys, let's let's try to get whatever LCIA. Let's be flexible. We can go back to them and tell them we can accept LCIA, ICC. We're really there's so many institutions you can accept. So pick one. They say no. It's the Nepalese Arbitration Center or nothing. What do you do? Any other comments, thoughts?
I think it's important to due diligence the centre, not just assume because you haven't heard of it that it's rubbish. For example, the Market Arbitration Centre under the Bovespa in Brazil, when I first came across it, never heard of it, but it's actually a very, very credible and good, well-organised organisation. So due diligence at first, not just assume, particularly if you're in that situation where you really don't have a choice, it's deal or no deal over there. It might not be as bad as you assume.
Exactly. I mean, this is what we do. We pick up the phone and call those institutions and interview them, or speak with colleagues, try to find out who they are, what they do, what's the mechanism for appointing arbitrators. Do they have kind of a closed list, open list of arbitrators? What do they do? I think so. You try to get familiar, with the institution. It's a question of risk appetite. How much risk are you willing to accept? And if local dispute resolution maybe, you perceive it as a risk, how can you counter that? What else can you do in the contract to mitigate that risk? Can you get performance bonds, for example, so that you ensure you'll get paid? So the risk of having to start a case becomes smaller, and your main risk is potentially being the defendant. So there are many things you would kind of do in practice.
Yeah. I would just speak up again in favor of another factor that hasn't been mentioned, which is related contracts. That one of the things that's quite important to us is having consistent dispute resolution and applicable law clauses in contracts that may relate to each other, such that you don't get inconsistent parallel proceedings, and you do have the opportunity for joinder or for combining, even at the agreement of the parties. I think that that's something that is often neglected, and I'd speak up for.
I just want to add that sometimes you come across at least what the business people think it's the project of a lifetime. And those are the terms that are on the table, and the counterparty will just say, well, it is what it is. If you want to come to my country and you want me as a local partner and you want to invest in this business, you have to take this dispute resolution clause because it's what we're comfortable with. And then, at that moment in time, you have to take a decision. If you decide to pursue the project, then the dispute resolution itself, it's not important anymore, but the rest of the contract, because you know that's what you have to deal with if you end up having a dispute. So you have to try to avoid getting to a dispute if you're not 100% comfortable with those terms up front. So you need to park that for a while and say, it is what we're going to accept. So deep dive on the other provisions of the contract. And what are the other protections available, such as insurance, for example? There are a lot of risks that are insured, like you can insure them, and like insurance, the insurance market has developed a lot over the past years. So there are a lot of risks that you can insure, and you have other tools available, and then it's not that relevant anymore. You just need to protect yourself with other available tools.
And I think that at the end, you might get to a point where it becomes less of a legal decision and sometimes a business decision. So you present to your internal clients a set of options, and you participate throughout the process of negotiation, the contract. And at the end, you have a scenario where you manage to ensure some of the critical points. You manage to come up with a combined clause, as what was discussed. You do the due diligence, you know that, okay, it's not perfect, but it might work. Those are the precedents that happened before. And you get to a decision that's more than legal, it's a business decision at the end. So it's not only the legal decision, but it's from the business as well. So I think it's...
And when you do have the opportunity to take the lead and select your institution, what do you consider? Are you able to assess the effectiveness of the institutional rules, the efficiency of the administration team of the institution, reputation, costs? What are the most relevant factors to you?
I mean, I'll come back to what I mentioned before about the dispute resolution policy, because having that debate was an essential part, because one not only chooses an institution, one has a kind of a ranking based on the fact that there will always be negotiations that take place. For us, there is all the factors you mentioned, plus the installed base of contracts, because you do not necessarily know the way that contracts will relate to one another, and having different choices made over time, even with the same partner, the same customer, the same supplier, it has its own dangers. For me, I would look for three things when assessing the effectiveness of the choice of an institution. The first is basically responsiveness to users. That's absolutely essential and is often overlooked. And I think that the institutions themselves have become a lot more sensitive to this. The ICC, as was mentioned in my biographical introduction, asked me to be the chair of the governing body, not just to be a member of the governing body. And that choice itself, asking a user, a corporate user, to chair its governing board was indicative of not just the ICC, but other institutions' embrace of the role of users. I would also point out to the fact that the ICDR has reached out continuously over time looking for feedback from its users at the corporate level. The LCIA has done something similar, and we see SEAC beginning to do this as well. So whereas in the past, the outreach was mainly to practitioners, to arbitrators, those were considered the key stakeholders, that outreach to users has shown that basically that factor is now well understood by the institutions. The second is the flexibility or the continuous development of the rules. We've seen the emergency arbitrator, we've seen fast track, we've seen joinder, we've seen other flexibility tools introduced in rules for a number of institutions, but we've also seen some institutions which are curiously static. And I'm looking for an institution that has the right balance between conservatism and innovation, because move too quickly and you create uncertainty for the installed base of contracts. Move too slowly and you may not keep up with what are necessary tools, in my view. The third is accessibility. That it seems surprising, but there are institutions which will not address corporate users. So, for example, it's quite easy to call the LCIA or the ICC and ask to be copied on correspondence. That is not the case where there are certain institutions that basically say, no, you must have an intermediary in the form of external counsel who act as your representatives. We do not recognize you as a legitimate speaker in our system. That's surprising, but I think that accessibility has got to be something you take into account.
Yeah, I think that I would add to those items, of course, and in Brazil right now, it's something relevant to us. Cost as well is something quite relevant. So arbitration sometimes they are seen of something that can be quite costly, and trying to find a reputable institution that also can provide reasonable prices, it's a combination that for us it's quite relevant. So just to give an example very quickly, so in my previous experience, we used to use CCBC quite often because it's a reputable institution operating in Brazil, and we had local arbitrations, would make sense a lot. Now having ICC with the local office there, which reduces a lot the costs for us, now we have more options in that sense. So this combination of flexibility, being able to be accessible, to adapt to the objective of the arbitration, in addition to having reasonable costs, for us is something quite relevant as well.
And have you...
Maybe just one point. I would subscribe very much to what Ivan and Karl were saying. One way kind of we look at institutions is from a corporate perspective, what do we need as a company, right? We are not in the business of fighting arbitrations or going to court. Our business, or my task, is to resolve disputes, and I have a toolbox for that, which includes litigation, it includes arbitration, it includes mediation, whatever hybrid form, and of course negotiations. From my perspective, ultimately, I don't have a preference for one or the other. I want to resolve the dispute. Now, if I go to an institution, what I would expect is that the institution mirrors my needs. So that's not only the narrow field of arbitration, it's broader. It at least, includes mediation, but also, kind of possibly that you have expert proceedings, dispute boards, and similar issues. And that's what I expect from arbitration institutions, that they develop by looking into what's the need of their users. Mediation is a big topic. That needs to be not kind of the sideshow that they do because you think we have to do it now, but that they seriously look into mediation. They look into kind of the bigger picture of dispute resolution. The German Arbitration Institute, they just adopted a new set of rules which have an interesting twist. The rules now say at the first procedural conference, the arbitrators must address with the parties the question of alternative dispute resolution. So you have, very early in the proceedings, a discussion about there's arbitration, we move that forward, what else may be out there? And to me, that shows some innovation and something where I see that the institution is really looking at the users, what they want, dispute resolution, and try to incorporate that in their rules. In my mind, that makes an institution more attractive.
Mm-hmm. And have you been involved in ad hoc arbitrations? Would you consider that option as an alternative to costs?
No. And the answer is yes, I have, and that's why my answer is no, absolutely not. My grandfather always used to say, there's nothing as expensive on this planet as cheap. And when it comes to choosing a mechanism of resolving disputes, you need and want the framework of an institution because it is only apparently a cost savings. And I've never seen that borne out in actual practice in any ad hoc proceeding I've ever been involved in.
All right. Talitha, you have negotiated contracts in some peculiar jurisdictions. In any of those negotiations, did you face a situation in which the deal didn't go through because you couldn't agree on the dispute resolution clause?
No, and I hope that never happens.
It's failure.
Well, just because at least as in-house counsel, well, our job is to pursue the business that is attractive to our companies, and I hope the dispute resolution will never be the
Deal breaker.
the deal breaker, and I think you can find solutions, or at least as I mentioned before, you can find tools that will protect you or will mitigate your potential risks. And if you work together with your team since the beginning, and I think that's fundamental for the success of all the projects. You sit down with your business development team, your technical team, and you do your proper work. I see no reason why the dispute resolution would be the no-go. And we've come across sometimes like that situation where like you're either dealing with the government, so it is what it is, it's take it or leave it, and if you want to do the project, you take it, and you protect yourself in different manners, or you're dealing with a local counterparty that they just don't feel comfortable. If you come and you say, it is ICC, it is English law, and you're like, well, you're in Africa. I have no idea what English law says about this, and why would I go with ICC? They're so expensive, and I don't really know, and I'm not really familiar how they work. And you can try to educate them. Sometimes they're open to those opportunities, and they take it as a good thing that you're there and you're open, and you can try to work together and make it work so it's not one-sided, but sometimes you just can't. And if it is an important project for your business, then I don't think the dispute resolution would be the obstacle, and it would be the no-go for the project. It shouldn't be, at least in my view.
And negotiating the dispute resolution clause, does that impact on the price of the contract? For example, would you be willing to pay more or charge less to have an arbitration seated in a neutral seat instead of the country of the opposing party?
And everything has a price. I wouldn't say it would directly impact in your price or your capex, but if you want to insist that, maybe you leave something else on the table. So, I mean, I don't have a particular experience where I would say we paid X more to have that specific governing law or that specific dispute resolution. But yeah, we had other cases where you just leave something else on the table because you think that's more important. So it has a price, and it costed us something, not necessarily a line in our capex.
Felipe, just to share a little bit on the previous question, in fact, just to provide you guys an example, probably out of what we're generally discussing here. So in Brazil now, with BHP, in fact, I'm dealing with, probably the Brazilians heard about, I don't know if the other ones heard about, but the Samarco case, which was a big, probably the biggest environmental accident in Latin America, most definitely, and in the world, probably one of the 5 biggest environmental accidents. A dam of tailings broke and impacted a full river, 19 people died, and we had 500 to 600 kilometers of river and regions around impacted by the tailings. So it was a big accident, and we're in Brazil right now trying to solve and to deal with that. And we negotiated for 18, 19 months with prosecutors and public defenders and governments and agreements to settle governance rules around how to implement remediation and compensation measures in that sense. And one big discussion was the dispute resolution clause. We took probably 6 or 7 sessions with public defenders, prosecutors, government companies, just trying to solve this specific issue. The complexity there was that we had technically 3 main parties, right? In one side we had the companies, the other side we had the government, and on the other side, surprisingly, we had prosecutors. So to come up with a dispute resolution clause in that specific example was challenging. We suggested a possibility for each of the parties to appoint an arbitrator, each of them, and those would appoint another 2, so we would have a panel of 5 arbitrators, We tried to come up with only 3 arbitrator solution. We tried to come up with a panel of experts solution to avoid the arbitration. And we never managed to convince mainly prosecutors that any of those options would be a solution. And we ended up with litigation only as the only option for us to dispute resolution. So right now we have only one judge that we have to take all the disputes, all the claims, all the questions about it, which is definitely not the optimal solution. And from an Australian perspective, from BHP perspective, it didn't really make sense. So it took some time for us internally to convince our internal clients to say, you know what, we tried, we presented the options, but at the end they're just comfortable with litigation solution. And it took probably, I don't know, 15 to 20 days to people internally to make peace with that. But at the end we managed to close the deal and we had agreements. But it was probably a difficult issue, a very challenging issue out of all the issues that we had during the negotiation of that agreements. Mm-hmm.
I can give you 2 examples where that has become a deal breaker. The first is in a negotiation which was pretty particular, but it was somewhere between a decision whether to go or no go with a partner with whom we had worked for some years, and that the discussion about the dispute resolution clause in the governing law mainly drew out the intention of that partner to pursue claims against us, and it wasn't really a discussion about a cooperation at all. They were just seeking advantage and were trying to improve their situation, and so I would encourage everyone to have a very honest, frank discussion, even sometimes offensive discussion, with the counterparty about why do you want this institution? Why is this governing law important to you? And if you begin to see that their reason indicates that the business goals are not the same as yours, that's something you need to feed back to the business team, which is what I did in that case, and they themselves came to the conclusion that they didn't want to trust that partner, and it did kill the contract. So the other one is, of course, the very particular set of circumstances surrounding intellectual property, trade secrets, co-development agreements. I would say that it would be a deal killer to put into a public forum a dispute about very sensitive technology that were co-developed, because you simply can't afford to have the risk that that's publicly disclosed, or to face the extortionate situation where you see that your technology is being stolen, but you are not able to enforce your rights because you can't effectively put into the public domain in a court setting or in a non-private dispute resolution setting of some kind, the arguments and the facts that you would need to defend it. And I've seen that become a deal killer as well.
And then maybe just, as we're talking about deal breakers, in terms of very dispute resolution clauses, what we've seen on and off are very peculiar clauses where arbitration clauses, where the customer says, the customer will appoint the sole arbitrator. So, customer appoints the sole arbitrator. The extreme version of this clause is that the customer appoints the sole arbitrator who may be a current consultant to the customer or a former employee. And this is, I'm not joking, those are dispute resolution clauses we've seen, and they're deal breakers. Where we say, look guys, we're not going to do this. I mean, this just doesn't make any sense.
How about you? Do you prefer capped fees? I understand in Brazil, the common model used to be a success fee, and that has been evolving and getting closer to the European model on an hourly rate.
Yeah, I think that I can share a little bit on that. It's funny because again, back in 2014, when I joined again Paranapanema, what I found there was a bunch of success fee-based contracts with no cap at all. And my first task when I got there was, man, you have to provide to us predictability, controls, limitations. We were not even at the heart of Lava Jato yet. Maybe, Felipe, you want to provide to the audience a little bit more details on Lava Jato, but it's probably the largest corruption investigation around the world, just compared to the Italian investigation some years ago. But because of Lava Jato, we changed a lot our behavior in Brazil. So at that time, I initiated to change contracts from success fee to, first of all, to cap the success fee, and then second of all, to turn into hourly basis contracts, and then in the hourly basis also define some predictability and define caps. It's funny because now I start listening, being with BHP, that the outside Brazil, some law firms are presenting the success fee solution as an alternative to the hourly based cap that we are now trying to implement more as a rule. So I think that there we went towards a process that would give us less exposure to success fee risks, which could be that we don't have control of, but we can have external lawyers sharing, splitting the success fee with arbitrators, judges, clerks, whatever. And that risk we really want to avoid. It's a big discussion about it. And also at the same time have more predictable budgets. Legal budgets are now quite relevant in the company. So understanding in advance how much you're gonna spend for that year, it's relevant for us as well. So generally we are working right now in hourly based and capped solutions. Not a lot of creativity, to tell you the truth.
I almost take the opposite approach, except for very small matters where it's simply just not worth getting beyond an hourly rate. I don't do hourly rates at all anymore. Basically, all of our advisors work on some kind of alternative fee arrangement, generally not success fees, although that's something we'll entertain. But nearly all of the advisors that work with us, we sit down with them from the very beginning, and sometimes in a staged approach that may evolve over time, but we don't do hourly rates at all anymore.
That's interesting.
And we try to cap as much as we can as well. And I think the stage and the staggered works quite well, because then you can limit the scope and you know exactly, can you guys not hear me? And then if you do have caps for the stages and for the phases of the processes, then you have more ability to understand exactly what is the scope of work, and you have less friction with your external counsel.
Some specific milestones, for instance, right?
Yeah, exactly. Then you have caps for the phases instead of have like one overall cap that eventually you hit the ceiling, and then you start to have friction with your external counsel, because they're like, well, now I'm just working a lot of hours and not getting paid, or eventually not getting paid what they would expect to get paid. So I think that works quite well.
I would also speak up in favor of understand the economics of law firms, of small firms, solo practitioners, large firms, and how those firms differ from each other before you try to approach it. An eat what you kill firm is going to have a very different incentive structure than a firm that's a solo practitioner or a sort of a collegial, sort of, I guess, lockstep type firm. And understanding the economics of the people you're dealing with is essential in getting the incentives right and aligning them with your own.
I think, it's a big topic, of course, for fee arrangements. And I think it's something that needs to be driven by the companies, not by the lawyers. The law firms will never drive this issue, right? And I think historically companies have not been very good in negotiating, fee arrangements with law firm. I think for a long time companies simply accepted that the law firm's bills on an hourly basis, and from a law firm perspective, that's paradise, right? You just put in, all the hours you want and you get paid. So I think that has significantly changed. For us, it's the same. We do alternative fee arrangements. And the way I look at it is, we're an engineering company. So what we do is we sell, a power plant for, a lump sum basis, $400 million. Our engineers are able to calculate essentially a fixed fee for a highly complex engineered power plant. When I then have a discussion with a law firm relating to a dispute under this contract, which is much smaller and much less complex, and the law firm comes back to me and says, it's litigation. It's impossible to predict what's going to happen. I'm unable to do a fixed fee, capped fee, anything. I need to do hourly fees. That you can imagine you don't get much sympathy from our side. So it's clear. It's for the company, I think, to propose how to do it. And that's what you guys are saying. You need to set out the different scopes, have subcaps, and all of that. But of course, you can do capped fixed fee arrangements for litigation. That's not a problem.
And who selects the arbitrators? It's the company, the law firm. What attributes you look for in your arbitrator?
I would strongly encourage all in-house counsel to have a dialogue about that, to make sure that not only what you know is taken into account, but your values are taken into account. So to turn to the second half of your question, what are we looking for? It's not often understood by outside counsel, though it should be, that one of the greatest values we're looking for in arbitrators is courage. We want arbitrators who are willing to take tough decisions when they present themselves, even if they may go to our disadvantage. And it is amazing to me that outside counsel are still focused on the question of substantive expertise or diary availability, and not that basic question of courage. The values themselves can be quite important as well. For certainly, I don't allow a list to be presented to me that doesn't include diversity candidates, which is something that's stated right up front. The values in terms of basically upholding some of the principles of ethics, compliance, and corporate social responsibility are things we want to see taken into account. And you will only see those taken into account if you are at the table when those decisions are made, and you don't just simply blindly follow the recommendation that outside counsel gives you. They have a certain expertise, they have a certain network, but you have as much right to be in that discussion as they do.
Let me share one story about that, because you just mentioned the word I was looking for in one specific experience. So we were looking for courage, right? We in a relevant case that I dealt with, that some people in this room was participating on that. We had a bad company case, right? We had a case where if we win, we survive. If we lose, that's the end of the company, right? And the decision there, and when I engaged the company, we were at the moment in that procedure that we already have had an arbitration decision, and we needed to revert that, right? We were initiating a new arbitration, and we needed to get a new decision that would be definitely against the first one, provided by respectable arbitrators, and so on and so on. So we were looking for courage. We were looking for people that will look into that case and be able to see it from a perspective that wouldn't be dependent or from any previous decision, that would be looking for the right and correct decision. And it could be against us, but we needed ethics, we needed commitment, we needed courage. And then I engaged myself in that process. So I wanted to make sure that not only me, but the company was aware of that process and participated in the selection. So, and it was really relevant for us to be able to participate in that process. So I totally agree with you.
And are there jurisdictions whether the pool of arbitrators is too small, or industries in which you cannot find arbitrators with the expertise needed to adjudicate your disputes?
I think the main issue is really transparency rather than the availability of the arbitrators. I mean, first I would echo what Ivan and Karl was saying. I think from a company perspective, it's key that we are taking the decision, that we are involved in selecting the arbitrators, and we are. That we, pull together the list, that we interview the arbitrators, that we need to, it's my interest as a company to show visibility when the arbitrator is selected, that it's also clear to the tribunal that it's not the law firm kind of dominating this exercise, but it's us, right? We are behind that. Diversity, as Karl is saying, is important. And we had a recent example where, from a large law firm, they proposed, I think, they put together a list of 5 arbitrators. If you look at the profile of each of the 5 arbitrators, they had exactly the same profile as the lawyer, the partner, the law firm was proposing them. Kind of, same gender, same age, same background, right? You look at the list, you think it's shocking, right? And that's not something where we just say, oh, it's shocking and we move on. It's something that plays a role when we select the law firm. When we look into our panels, that's part of a discussion where we tell these guys, look, that's not on, that's disappointing. You get, that's maybe the point where you say, look, there are so many other law firms, why work with them? So we're very much involved in the process. And then I think it's an old topic in the arbitration world, but it's always difficult, we all rely on our network, on calling up people, on kind of, trying to find out who that person is, what experience they have, and, it's basically picking up the phone. There's not enough transparency around in terms of really understanding the arbitration community, which of course hurts the younger arbitrators who are kind of out there, trying to make a career. And then it's more difficult to get into the market.
I suppose I come at this from the perspective of I started my career prosecuting domestic violence crimes to juries who had an average of an 8th grade education. And therefore, I guess the experience I've had is that there is no such thing as a dispute that is so inherently complex that you are stymied by the fact that an arbitrator doesn't have the exact experience in that area. It is the job of the advocates, it is your job to make that dispute understandable, to boil it down into its crystalline essence, and to make sure that the essence of the legal dispute and the factual dispute is apparent to whatever audience is hearing that. That's not to say that you don't care who your arbitrator is, but the qualities of the arbitrator, of transparency, of courage, of open-mindedness, are actually quite a bit more important to me than the exact experience in some particular industry, because I do think that you can communicate that effectively using good advocates, using good experts, and using the right arguments, focusing only on that which matters. And on that basis, I would say that we should spend a whole lot less time trying to gain the attention of the very few exalted, aristocrats of arbitration, Jose, I love you, but you're not the only one out there. And that we should give our time and attention to some younger candidates who may actually have the quality and the courage to get some of these things done. Not that the older, and more experienced arbitrators don't have those qualities, but that we do need to diversify that pool. And when we think of diversity, it can't just be based on gender and national origin, it has to be based on age. And that we, as the advocates, have to do a much better job of making the dispute comprehensible and clear to the people who are making those decisions.
Just to add a comment on that, and going back eventually to your first question, when you asked about the decision on going from litigation or arbitration, and in the specific example of Brazil, one of the issues that I take in consideration is the arbitration environment right now. So we would have, it is my opinion at least, that we don't have enough arbitrators in Brazil right now. So we would have arbitrators with 30, 35 cases. So with a lot of things, and arbitrators exchanging hats as lawyers and arbitrators at the same time. Or in one arbitrator you had arbitrator, in one arbitration you had the arbitrator, the other one you had the lawyer. So in some circumstances, it brought to me, as an in-house lawyer, some discomfort about it. So having more opportunities and going to younger lawyers or to younger arbitrators, to other options, not being fixed at the obvious set of arbitrators that are there, I think it's quite relevant, and we should be pushing for that, most definitely, yes.
Interesting. And how do you select your law firm? That's a question I'm particularly interested on.
We exclude anyone that we have ever known before, and then we start looking for new ones. No, sorry, I'm just joking.
I'm pretty sure at your companies it may work differently. We don't have some companies do have panels of pre-approved law firms that they are allowed to work with, and they do a lot of due diligence, they negotiate fees, and they do all of the pre-work in advance. At VTTI, we don't do that. So we rely a lot on our network and people that we trust. And to be honest, I mean, there are a lot of available, competent, knowledgeable lawyers out there. So there's a lot of who you want to work with. So a little bit of courage and how much risk they're willing to take if they do see you as not only as a client, but as a partner. And if they want to work together as a team, that for me has a big weight. Someone you like to work with, and you know that the external lawyer is partnering up with you, not only seeing you as an additional client on their list, as like a money maker, but rather like taking the leap and working together. And I think it needs to be something pleasurable. And it's sometimes when you're talking about litigation and arbitration, it's already stressful enough to be like your external counsel is someone you need to manage all the time, or you don't get along with. And I think there are enough available, knowledgeable, experienced lawyers out there, so you can make a pick based on your personal experience and how you want to work together as a team. But I know maybe your companies will have a fixed panel of law firms, so I don't really know if your experience is different.
We do have a panel system, but it's flexible. It allows any lawyer choosing a law firm to include those who are not members of the panel if they can provide a justification for it. If there's a particular competence or a particular set of experiences that are relevant, we're quite flexible there. But more than anything else, when selecting the panel, and the panel is reviewed on an annual basis, and there are law firms who leave as well as who join, really the three things that I'm looking for more than anything else is the ability to actively and even violently disagree with me. I don't want obsequious lawyers. I want lawyers who are going to say that is the stupidest idea in the history of bad ideas I've ever heard, and I don't care if you're signing the checks. I'm going to tell you exactly why. So I wanted a real sparring partner, someone who's going to tell me I'm an idiot, not that I'm just really smart. And I demand that of my employees, not just of my lawyers. The second thing that I'm really, really looking for is a common set of ethics, because it's absolutely essential that when you are not in the room, you feel represented. I know that the point that you made before, Ivan, is absolutely excellent, that you want to know that your lawyers will never do something that will compromise your set of ethics, and that's essential. And the third thing might seem a bit surprising, which is I think you strengthen the partnership and the relationship when you lose a case together, a big one even. Because when you are able to go to the board and take responsibility together with something that did not go your way, even against your predictions, maybe even did not have the financial quality of a provision that was in place to protect you, etc., and that person is side by side taking responsibility and willing to sit down for a post-mortem after the fact, what did we learn from this? You better believe that that's a good partner going forward because you've absorbed the lessons the hard way, not just drinking champagne, but drinking some scotch and soda as well.
So we operate a panel as well, but it's maybe similar to what Karl is saying. It is flexible. I think you would distinguish between kind of you have certain areas where you're spending a lot of money basically, and there you operate a panel, and the panel gives you a platform to really negotiate price, and their price makes a difference. If you talk about really big matters. But we also have kind of a large share of the panel, which is so that panel is relatively small because you negotiate price, right? To get in, you need to give a good discount, and not only discount, but also it needs to kind of work in terms of quality and all of the other points that Karl mentioned. I think then there's a panel which is much broader and more flexible, where you kind of look at the particular matter and see which law firm fits. And there's the flexibility also to go outside the panel and get other firms. And what we typically do is, kind of get competing bids from 3 firms and look at them. And that's first you learn all about a case. You can compare price and you see, in terms of quality, what works. And I think another element, what is important and what has worked for us well over the years, to grow relationships with sole practitioners, kind of with small firms in small places. And I think it's similar to what Talitha is saying. There are simply absolutely fantastic lawyers out there. They're no big names, but they do a wonderful job. They give you the quality. You work. They know your business. They're very established. They give you good quality, and of course they give you good price. And that's also a very important element for us.
I'd say that just to add a little bit on that, and I agree with what you guys are saying. One thing that I face currently, which is trying to find a balance between, and maybe the external lawyers now are being exposed to that as well, it's to find a balance between when the supply chain team is going to conduct the process and when the legal team is going to weigh in and find the balance to choose to have the final decision there. And I still can see some of my colleagues in Brazil having this battle right now, trying to establish themselves as the final decision maker. In Brazil, a lot of, again, because of Lava Jato and a lot of compliance issues there, procedures got tight, got more complex, and in some occasions it was just decided that supply chain would have its independent process, and then we are going to get to know the law firm chosen at the end of it. And of course, it doesn't work. So we are now finding this balance to be able to have us from legal suggesting at the beginning of the process to the supply chain the options, conducting the process with it, and bringing all those elements that you guys already mentioned to the decision process. It cannot be cost only. It has to be a balance. And at the end, I totally agree with what you guys said and what Talitha said specifically. I think it's more a relationship with it's less of a relationship with the law firm, but it's more a relationship with the professional, with the individual, with that specific professional that has that specific quality for that specific case. And if you build that relationship, mainly when you lose, and you learn how to trust in each other, how to support each other, that's going to be a big difference for the next case. So I think that we still, which is very good, to tell you the truth, coming from Brazil, and whoever knows Brazil coming from Bahia, it's very good to know that we're still based on relationships and good ethics and good principles. That should be the basis of the choices.
If I could just make one more remark, sorry to intervene again, but you reminded me of something important. There's a professor here at the University of Oxford, Richard Susskind, who's written a couple of books, The Death of Lawyers and the Future of Lawyers. And I'm a great admirer of his. And one of the points he makes about legal services is know what you are buying. That's dispute resolution can be broken down into 11 discrete sets of tasks. And don't think you're hiring a law firm or a lawyer to do all of those tasks. Instead, there are really only 3 of those 11 tasks that discretely require the sort of legal mind. And I think it's quite important, Ivan, that you say you're building a relationship with an individual and a team of individuals, right down to the paralegals and the professional assistants. And you are not building a relationship with a behemoth that is going to do your e-discovery and things like that, for which you can hire other contractors. So don't exclude the bright minds of solo or small practitioners because they don't have the international name or weight or 10 offices behind them.
Very well. We would like to open for questions from the audience.
Well, my experience very strong. Being a negotiator, legal consultant, arbitrator, lead counsel, chairman of arbitral tribunal, but I deserve my behavior myself. Now, most of the discussions were concentrated on either arbitration or litigation. Now, I want to know from the client's perspective, what would you think about the multi-tiered or multi-layered dispute resolution clause? You may have negotiation, you may have mediation or conciliation, then you may have arbitration. If not arbitration working, then you can go for litigation. So, from the client's perspective, I'm just wanting to know if you have this experience or what considerations you might have in regard to this kind of exercise. Thank you.
I can quickly. I mean, I'm not a great fan of complicated and long dispute resolution clauses. My preferred clause is very simple. It's essentially, I always say, it's copy pasting, from one of the institution's website. It's my preference would be mediation followed by arbitration. And keep it simple. I don't like a dispute resolution clause which goes over 2 pages and which sets out that, first discussion at the project level. With if no resolution within whatever 48 days, then it goes to a higher level management, senior management, whatever. I think far too complicated, far too complex. It's typical. Disputes are complex. You want a simple dispute resolution clause. I would use one of the tested, standard clauses from the institutions and stick with that.
I totally agree. I mean, our dispute resolution policy allows cured clauses only in absolutely exceptional cases. I love mediation, and I would tell you that the worst thing that ever happened to mediation was that it was rendered mandatory, either by judicial or legal or contractual means, because what happens when you have a mandatory mediation is no one takes it seriously. I believe that John F. Kennedy was right. We must never negotiate out of fear, but we must never fear to negotiate. And that's a principle that I instill in my clients as well as my lawyers.
Now, I would have to agree with short dispute resolutions, but just a remark, that does not prevent you from trying to negotiate until you get to the point of litigation. So sometimes you're very worried in putting on paper that, well, steering committees need to meet and senior management need to meet, and then you escalate to someone else and you have pages and pages of dispute resolution. But having a short dispute resolution provision doesn't prevent you from doing everything else if you want to avoid a litigation or an arbitration. So keep it simple, because you can always invite people to sit down on the table and negotiate, and if they're open to, and if you have a JV partner, for example, then you want to avoid litigation and you want to avoid a go to war as much as you can. So it will be in the interest of the parties to do that. So you don't need to have that written down on paper.
Thank you very much for your presentations. And my name is Diego, I'm from Ledge Finance. And one of the topics that have been widely discussed in the academia is international public policy, or public policy, local public policy. I would like to know, from the client's standpoint, how do you address these topics, since even though there are relevant precedents in the International Commercial Arbitration Forum, they're still vague to some extent? That's the first question. And the second question is, when would you consider it is very important to choose a foreign arbitrator? Thank you.
That is a fantastic question. Thank you. And you're absolutely right, but it brings me back to something I said before. There is no more important reason to focus on the ethics and the social, justice focus of an arbitrator or counsel or any participant in the process than the vagueness and uncertainty created by conflicting or uncertain or, shall we say, non-courageous judicial jurisprudence in the area of public policy. For instance, an arbitrator with the right focus will see clearly that encouraging settlement in the case that has significant public policy concerns is futile, and that their particular courage will be required on the part of the arbitrator to effectively elicit the arguments the parties may be unwilling to make. You may know that there's an excellent, case that kicked all of this off, the Metaltech case, Metaltech versus Ukraine, in which it was the arbitrators that effectively elicited the proof of the bribery that was ultimately key. And that I deeply, deeply admire the arbitrators for having the courage and taking that on as an issue the parties did not themselves initially argue. I've seen that in other cases as well. The nationality issue is also an excellent element to that question, because I think you'll be aware also that there are different if you could say there are different criminal or civil sets of responsibility that may apply to an individual arbitrator according to his or her nationality, and therefore you need to be very cognizant of the fact that that arbitrator may be looking at his or her own personal liability through the lens of the public policy arguments that you're making. And it's a wonderful question, and thank you for raising it.
I would just add one point in terms of the international arbitrator. Sometimes not only, and we were discussing before the arbitrator, but sometimes you need an international expert. So therefore, you're going to push to have an international arbitration and an international arbitrator to be able to bring to that specific arbitration an international expert, because sometimes in your jurisdiction, you just don't have an expert that's going to be good enough or experienced enough to provide an input on that specific disputes.
Thank you so much for your presentations. My name is Joanna Rego. I'm from Regus in London. You've talked a little bit about budgets, about strategy, about litigating and arbitrating in difficult jurisdictions. And I see there are a few litigation financing entities and arbitration financing entities in the room. I was wondering how this new class of financing has actually influenced how you manage your dispute resolution divisions, and not just in terms of budgets, but also in terms of the strategies, because there's lots to say as well about offsetting debt and offsetting claims to other entities. So I was just wondering what your perspectives were on this.
Okay, I feel like I'm hogging the microphone. I'm not trying to get fair.
We are happy for you to do it. We are quite comfortable about it, don't worry.
I'm very excited about that question too. I have a bit of a heterodox reputation in talking about that, because I'm tremendously excited about third-party finance. I think it's a wonderful tool. It's badly underutilized by corporations and by defense or respondents in arbitration, in the sense that I think it has major advantages if you use it as a financial tool. It's not right in every set of circumstances. Burford Capital published an excellent report just a few weeks ago, which really rounded out the debate, which unfortunately on the respondent side, on the defense side, on the corporate side, has for too long been focused on the risks to confidentiality and the risks to of leaks caused by sort of divisions between teams involving third-party funders. I'm excited about it. I have active dialogue with my finance team and with sort of external parties about what role it may play in the future. And I just want to speak up in favor of having an open mind when it comes to using that tool.
Maybe one comment. So we look into third-party funding sometimes. So we used it in cases, mostly when it came down to enforcement of arbitral awards, and then it worked quite well because they brought some expertise to the table which we didn't have and wouldn't get, and you found some good arrangements. I think it was good. We also tried, in certain cases, kind of to sell our litigation basically to third-party funders, and we're very excited about it. Our finance team was very excited about it. When you then actually sit down with the third-party funder and negotiate, the deal, after a while it was less exciting, in this particular case it didn't really work out. So same as Karl, I would support third-party funding. I think it has a role to play. It's a good tool. It kind of broadens the market. It's not going to resolve all of our issues. And very often, I think the cases where companies like ours would look to third-party funders are probably also the cases where third-party funders are less interested in taking on the risk. Really.
Just to add another perspective to that, it's interesting to see you guys mentioning that, because what I see currently, at least with BHP and some of my peers in Brazil, it's resistance to that. So people still not really trusting about the solution, not really comfortable about, and probably it's just a lack of real knowledge about the structure, but people uncomfortable about losing control of the procedure, uncomfortable about having people pushing for settlement when it's not the moment to settle. So some of those items that is still unknown, in fact, on a practical basis, that get people uncomfortable and with some kind of resistance to that. That's at least how I'm seeing it so far. But to tell you the truth, I'm curious about it. Let's see if we can try soon something like this.
We have time for one last question.
It's Michael Pugh, London South Bank University. So my question is, to what extent do you think we have, that the infrastructure that we have, and namely the New York Convention, is fit for purpose at the moment? What I'm thinking of is the diverse interpretation of the public policy exception and Article 5, and also in practice, in North America, different objections that can be put forward by courts for enforcement, against enforcement of arbitral awards where there is an insufficient connection with the state in which enforcement is sought. And I'm also thinking about China, but not uniquely, where there can be very long delays in actually enforcing a foreign arbitral award, and by the time enforcement takes place, the asset has been squirreled away out of reach.
I'm afraid so. Sorry, it's me again. Excellent question, but I would submit that none of those challenges are terribly new or recent or unique to the New York Convention. That any diplomatic instrument has always been subject to the varying interpretations it's given in local courts. And I would say that one doesn't really even have to look as far afield as China to find examples where the spirit of the New York Convention is actively undermined. If you look even in European states, the differences between the number of successful recours against arbitral awards, even before the enforcement stage, you find there's a radical difference in the jurisprudence. In a recent Paris Court of Appeals decision in an Alstom versus Alexander Brothers case, it provides an example of how a state may seem to actively undermine its own interests in maintaining the reputation of being a balanced jurisdiction for enforcement purposes or as a seat of arbitration. And I would caution all of us from assuming that there's a steady march of progress along the style of an English interpretation of history, that as nationalism begins to afflict national courts, etc., that arbitration is safe from that, because certainly at the enforcement stage, you're quite right, that we are all vulnerable as nationalism and sort of me-firstness begins to afflict the spirit of judicial interpretation as well.
Oh, thank you very much. It has been very insightful and a pleasure to have you here today. Thank you.